There are so many different types of restraining orders that are out there, and not everyone understands the type that they should actually apply for and why it matters. It's extremely important to know how to file these because consistently they come into my office filed incorrectly and they find themselves not being able to meet the burden of proof because they have chosen either a civil harassment restraining order. Just make sure or contact an attorney prior to filing these restraining orders in order for you to know that you have selected the correct one so that you can receive the correct protection. This is the only type of restraining order that can be granted if this is the sole basis for the request of a restraining order. Today, I wanted to talk to everyone about a topic that has been coming into my office quite consistently, and those are restraining orders. Restraining orders are a process in which you can apply to the courts for protection for a variety of reasons. The reason why I thought that it was an important topic to have a conversation about is because there are so many different types of restraining orders that are out there, and not everyone understands the type that they should actually apply for and why it matters. The first type of restraining order that is often in my office is a domestic violence restraining order. A domestic violence restraining order is a restraining order that is eligible for individuals who are married, who were previously dating, are currently dating, have children together, have lived together in a romantic relationship, or are related by blood. These relationships carry with them a reason for individuals to continue to have contact with another, and they are a specialty relationship that allows for the courts to have a lower standard of proof to grant a restraining order rather than some of the ones that we're going to discuss later. In a domestic violence restraining order, you do have to plead that you are either married, dating, formerly dating, have children together, or related by blood in order for the lower standard of proof to apply to you. Once you establish that the prerequisite relationship exists, you can file a domestic violence restraining order, which will be heard in the family court. The standard of proof in a domestic violence restraining order is going to be by the preponderance of evidence. The reason why this is important is because this is the lowest standard of proof that an individual has to meet in order for a restraining order to be granted. That means that you only have to prove that more often than not, the facts suggest that you need protection from the restrained party. So you're looking at about 51%, which is barely over a 50-50, and it is the easiest standard to meet. If you qualify for any of these relationships, it is highly recommended that you file a domestic violence restraining order rather than a civil harassment restraining order, an elderly abuse protection order, and/or workplace violence protection order. And the reason for that is that the domestic violence restraining order is the only restraining order that's going to give you a permanent restraining order at the 51% level rather than the higher standard of proof of clear and convincing evidence. I want to make sure that everyone understands that clear and convincing evidence does not mean beyond a reasonable doubt, which is the standard of proof that is going to be required in a criminal action. They are a different standard of proof in that beyond any reasonable doubt means that there are no other facts that could lend to an explanation for the crime that occurred or the motive or what actually did in fact occur. By clear and convincing evidence, that means that it is more plausible than any other explanation that you have met your burden of proof, rather than there not being any other single option that could exist. It's just a much higher standard of proof. There is not going to be a percentage that is equated to by clear and convincing evidence, but you do need to understand that you need to have very strong evidence to persuade the court in order to grant you a civil harassment restraining order, an elderly abuse protection order, or workplace violence protection order. And the reason why is that any type of restraining order, including a criminal protective order, is going to preclude the restrained party from having firearms, ammunition, or body armor. It is also going to go into a centralized database for all law enforcement agencies to be able to access to say that you are a restrained party, which could give them additional means to search your home if they believe that you are in violation of the protection order, or that they could know that you are a known person that could potentially pose a violent threat to others, themselves, or to the police officers. And so in determining which restraining order to apply for, if you do have the prerequisite relationship as your spouse, as your significant other, as your child, as your mother, as your brother, as someone who shares kid with another person, it is highly recommended that you file for a domestic violence restraining order, because due to the prerequisite relationship, it is the easiest restraining order to obtain. If you do not have the prerequisite relationship, then you need to look to the 3 other types of restraining orders that exist. Those 3 that I've previously mentioned are the civil harassment restraining order, the elderly abuse protection order, as well as the workplace violence protection order. Each of these 3 restraining order types are going to have specialized filing requirements. In order to file for an elderly abuse protection order, you need to be over the age of 65 or considered to be a conservatee or a protected party that's going to elevate your status to where you would have protection over and under the elderly protection abuse standards. If you are 65 years and older, the standard is still by clear and convincing evidence. However, it is going to also include that you can file this type of restraining order, even though the only type of abuse is going to be strictly financial abuse. The reason that this exists is because individuals who are over the age of 65 or are under a protected class or a conservatorship are going to be more susceptible to coercion and duress in order to be able to convince someone to give you access to their financials, for them to use your financials, or for you to be abused financially because you are being restricted from your own money. This is the only type of restraining order that can be granted if this is the sole basis for the request of a restraining order. Elderly abuse protection orders are dealt with in probate court, and that is because the Elderly Abuse Protection Act falls under the probate code under California law rather than in the civil code and or the family code. It is important to note that if you are 65 years or older and you are filing against someone who is your blood-related relative, it is still suggested that you file your restraining order in the family court, because the standard is still going to be significantly less, unless the only type of abuse that you are sustaining is financial abuse only. Under those circumstances, you would still want to file in probate court to request an elderly abuse protection order. But if there are other types of abuse, such as physical abuse, emotional abuse, psychological abuse, duress, coercion, people are not allowing for you to see other family members and they're alienating you from those family members, then you want to file in family court, because the standard of proof is going to be significantly lower. If you are 65 years or older and you are stating that you do not have a relationship with the defendant, however, you are more than just merely strangers, and you are over the age of 65, it then is going to be advised that you file under the Elderly Abuse Protection Order, because there are going to be special types of protections for those individuals over the age of 65, under protected classes, as well as those under conservatorships, because the probate court believes that those individuals deserve to have extra protection above and beyond those that do not fit into those 3 categories. If you are filing a restraining order against a stranger and you are under the age of 65, you do need to file what is called a civil harassment restraining order. And that is for individuals that are former friends, neighbors, acquaintances, as well as people that you have never met before. A lot of times these individuals can be new spouses of the individual whose baby mother or baby father is creating issues for yourself, but you do not qualify for the protected class for a family law restraining order, a domestic violence restraining order, because you yourself do not share children with the respondent, and you are just the new spouse of your partner who shares children with that individual. So if you are attacked by your partner's former spouse, you would file for a civil harassment restraining order because you would not qualify for a domestic violence restraining order unless you had adopted the child at issue. Under those circumstances, you then would qualify for domestic violence restraining order. Otherwise, you have to file in civil court under the civil harassment restraining order provisions. A civil harassment restraining order is going to be significantly harder to achieve and to have given to you by the court than a domestic violence restraining order, because the standard of proof, again, is going to be by clear and convincing evidence. This is important because you need to make sure that you're not wasting your time, the court's time, and that you do not subject yourself to attorney's fees awards for filing frivolous civil harassment restraining orders. The prevailing party in a civil harassment restraining order, as well as any other type of restraining order matter, does have the ability to ask the court to grant attorney's fees and costs as the prevailing party. This typically occurs quite often if you are the restrained party and you are successful as the prevailing party. The attorney's fees is going to be much easier to receive. However, the prevailing party provisions under the Civil Code, Family Code, and Probate Code all do allow for the respondent and or defendant who successfully defends a restraining order to receive their attorney's fees and costs under appropriate provisions. So if you are filing frivolous restraining orders, you do need to make sure that you are aware that it is possible that you could pay the attorney's fees of the other party if you are not successful in your attempt. It is most often stated that a civil harassment restraining order is going to be granted in areas where there is significant physical abuse and threats to your life, whereas neighbor disputes regarding property lines, surveillance, cameras, code enforcement, police officers' calls to the house are not typically granted because they're not going to solve the problem, as well as civil judges in these areas see that these are issues that need to be fought out in a regular civil courtroom regarding a property line dispute, trespassing, or other issues. However, if the aggression or behavior of the restrained party rises to the level of significant stalking, significant disruption to your peace, to threats, to physical violence, to emotional violence, then you can still ask the court for protection under the correct circumstances, so long as you can meet the necessary standard of proof of clear and convincing evidence. Again, even between a stranger, if you are physically assaulted, you are going to meet that specific standard of clear and convincing evidence because they have breached your personal space, invaded your privacy, and laid hands on you. But again, I caution people who are neighbors who simply do not like one another to file civil harassment restraining orders, because despite them being potentially granted on a temporary basis, that does not mean that you are going to be successful on a permanent request. More often than not, you are going to fail to meet your burden and you could subject yourself to attorney's fees. So use these civil harassment restraining orders lightly, especially if there's not a threat to your physical safety. And the last type of restraining order that I'm going to discuss today is a workplace violence restraining order. These restraining orders exist for business owners and co-workers. These restraining orders have to do with protecting you from harassment or violence in the workplace and precluding the individual who is perpetrating this violence towards you or others in the workplace from visiting that specific workplace and from contacting either the employer or the co-workers. An employer can file a workplace violence protection order against a client, a customer, or a former employee on behalf of the employer, specifically to protect the location of the workplace and all of their employees, specifically from having individuals come in and cause havoc or harm to the workplace and or their employees. This is the only time that you can specifically request the protection of others who do not live with you or that are not specifically under your care and concern. This is specifically so that the employer can reach out on behalf of the employees as well as their clients and customers for their own protection despite not living together due to the work-related relationship of each individual coming together under one roof. The typical scenario wherein these restraining orders are granted is if you have an irate customer that comes in and physically assaults an employee or threatens to do so. That person can be precluded from coming into the workplace as well as contacting any of your employees, clients, or customers in the future so that those individuals can be protected from harassment and disturbing of their peace. This also equally applies if there is an employee who refuses to act accordingly, refuses to leave the workplace after they've been fired, consistently come in after they've been fired, or no longer have the right to be on the premises, and they need to protect the other individuals who work for that specific job. This is a particularized and specialty restraining order that grants the courts liberalized orders to protect others. So if you fall under any of the other categories, you are related to the individual, you are over the age of 65, you share children together, and you do not work together, this would not be the appropriate restraining order for you to file. These are the types of restraining orders that employers file to protect their assets and their employees, as well as their clients and customers. So this is something that if you do not find yourself to be an employer, you should look to an additional type of restraining order, because those are the ones that are going to give more credence to protecting you and your loved ones. This is going to protect the employer from having unnecessary lawsuits filed against them for not protecting those that they need to protect, either as employers or as individuals who are allowing individuals to come into their area of business and be protected from unnecessary and unwanted violence. The workplace violence protection order is still going to have the same standard of proof as your elderly abuse protection order and your civil harassment restraining order, which is clear and convincing evidence. So you want to make sure that you are filing these types of restraining orders only under the necessary types of behaviors. If someone is coming in and has physically assaulted you or one of your employers, that qualifies. If someone has come in and threatened you or your employees, your clients, or your customers, this is the appropriate type of restraining order to get issued to protect your specific workplace. If you need to protect yourself individually, on top of you being an employer and your specific place of employment, you still should probably file in conjunction with your workplace violence restraining order, a civil harassment restraining order to protect yourself across all bases. It's extremely important to know how to file these because consistently they come into my office filed incorrectly and they find themselves not being able to meet the burden of proof because they have chosen either a civil harassment restraining order when it should have been a domestic violence restraining order, or they should have filed a elderly abuse protection order because of their age and received these special protections. Despite the standard being the same, you are going to be given special credence in probate court if you are over the age of 65, a conservatee, or under a protected class, because that is what the probate court and the probate code is offering as an elderly abuse protection order. It is also going to protect you against purely financial abuse. And so just make sure or contact an attorney prior to filing these restraining orders in order for you to know that you have selected the correct one so that you can receive the correct protection and not have to prove your case beyond a clear and convincing standard when you really should have been able to do beyond a preponderance of the evidence. If you have any questions, feel free to call the Haynes Law Firm and check the station for additional videos and tips and tricks in the area of family law in California.